Welcome to the Lemkin Law Podcast, real talk on divorce and family law matters.
Welcome to the Lemkin Law Podcast, real talk on divorce and family law matters, where tough conversations meet real advocacy. Hollie Lemkin is a family law attorney and fierce defender of protective parents. If you're navigating a high-conflict divorce, custody battle, or feel like the system's not listening, you're not alone. This show is here to give you clarity, truth, and a little fire to keep you going. Let's talk about what really happens behind the courtroom doors and how to fight back. I'm Heidi Mack, and today's episode is Emergency Custody Orders, What You Need to Know Before You File. Thank you again for joining us, Hollie. It's always a pleasure.
Oh, it's a pleasure to be here.
Thank you so much. Well, let's get to it, Hollie. What exactly is an emergency custody order, and how is it different from a regular custody modification?
An emergency custody order usually involves, like its label, there's an emergency, there's been a problem, there's been a material change in circumstances is usually the status or the standard that the court uses in determining whether it's going to put that issue on its emergency calendar or its regular calendar that's heard in the ordinary course of business. Usually it's something like there's been a radical change in the behavior of a child, or there's been an absence of the other parent who isn't seeing the child, and whatever's causing that to happen. It has to be some emergent, unknown, previously discussed or disclosed situation where there's a child at issue and it's affecting the child.
Then what are a little bit, more detail, what the situations does a judge typically grant an emergency request, and what doesn't meet the legal threshold?
That's the court's job, is to determine if the request meets the court's threshold for an emergency. And if the court has had any previous experience with these parties, the court gets a good sense of what both parties are about, what the situation is about, how many children are in this case, what the finances are basically like, what the living situation is, who lives with the children, who does not. And the court has pretty much made a snap decision. I hate to say this, but they do. A snap decision about what is the quality of the parents who have custody of the children. Are they good parents? Are they solid parents? Do they have the best interest of the children at heart? Do they not? Are there any substance abuse issues? Is there any domestic violence still going on in this case? Or because those will definitely cause emergencies to take place. So if one or both of the parties are using drugs or alcohol in an inappropriate way, that will cause an emergency hearing or emergency situation. Or if there's the other major factor that causes emergencies is domestic violence. So if there's a domestic violence issue that's going on between the parents in this situation, that will likely, I hate to use the word guarantee, but it is likely it could very well cause one or multiple hearings that are emergencies because of domestic violence abuse. And don't fool yourself. Domestic violence does go both ways. It can be mother hitting father or father hitting mother. And neither one of them is good, obviously. But most people say, oh, well, it's father hitting mother. No, not always. It's more predominant that father hits mother, but it's not the only situation. It could actually be a sibling hitting another sibling. It could be the sibling hitting a parent. When you have human interactions going on, there's all kinds of combinations that you can think of that would cause an emergency. The difference between that and a regular scheduled hearing is, first of all, the other hearing was scheduled and known, and the issues were briefed to the court. The court's aware of it. The court has had a chance to review the filings and the paperwork so that they get a good idea of, okay, I think I'm going to order this because this would hopefully help resolve some of the issues in this family and calm things down, or get some relief for the one parent or the other who needs some financial help, or grant a request of one of the parties to move to a different place so that they can have a better home environment for the children. The children will always likely be the priority issue in anything brought before the family court. They are the king of the court, as I say, because that's what drives the issues, is what's in the best interest of the children, because that always comes first and foremost.
Mhm.
So I hope that answered your question. If you need more, I'm happy to give it.
Of course, of course. I mean, in your years of experience, obviously you don't want to see this happen, but does it happen a lot?
Yes, it does, unfortunately, because people just don't. I hate to say it, but there's a lot of circumstances where people just don't act like adults and they don't stop
Mhm.
to think, what's the important thing here? Who's the important thing in this circumstances? Are both parents clean and sober? Do they drink? Is alcohol a factor? Because if alcohol's a factor, all bets are off. If drug use is a factor, all bets are off. You don't really know what's ever going to happen. And that's what makes it more difficult and complicated and heartbreaking. So you can't ever really say, okay, well, I'm going to schedule an emergency for this month. You can't. There might not be one that month. And the following month, there might be two. You don't know. So you just have to be flexible. The best thing I can say to most litigants and to most lawyers is be flexible. Learn how to be flexible and on your toes.
Oh, yeah, yeah, for sure. Well, then, so, again, we don't want this to happen, but if these cases escalate, how does a court define imminent harm or danger when it comes to the children?
The likelihood of it being repeated is usually the first assessment that the court makes. Is there a likelihood that this situation will repeat and continue? And
Mm.
if they get to the answer of yes, then that's when they take it up as an emergency. If they say no, this was a one off, we think we can set it for a regular scheduled hearing, they will not hear it that day. They will set it for a regular scheduled hearing. And that's their determination. And hopefully, who is ever writing the paperwork for one side or the other has forethought enough to say, I need to put those factors in my paperwork to the court so that they get the idea. This is likely to repeat. It's not a one-off, and I need you to make orders today to calm things down.
Then what are the types of evidence then actually that make a difference in these emergency filings?
Physical abuse, emotional abuse, monetary abuse. Um, are the minors included or not included in whatever event took place? If the minors are included, it's an emergency. They won't let a child go into a situation that has a likelihood of repeating and has affected a child, negatively and materially affected a child. Um, so those are the kind of the basic factors that the court looks at. Again, the children will always be the court's priority.
Mhm. Are there common mistakes that people make when they're trying to file on their own or if they're like rushing the process?
Absolutely. They don't know who they're writing to, is the easiest way I can say that. If they don't have a good understanding of what the judge is tasked to do, then they don't write to the judge. The best thing I can tell anybody is if you're writing an emergency order, or you're writing any order for that matter, or request for orders in that matter, know who you're writing it to.
Mm.
Play to that. Your strength is to play to that individual who will be issuing that order or not, depending on how good of a job you did in making your case to the court.
Can you file too many? Like, can you file too many emergency motions? Will that actually hurt your case in the long run?
In the long run, it does, because the judge gets annoyed with you. And I've been in many courtrooms where the judge has gotten annoyed and said, you know better. You know you should have just filed that as a regular motion instead of an emergency motion. And they can't tell you no, you can't, but they chastise you heavily.
So then whenever you're, helping your clients, how do you help them decide whether they truly need to file an emergency order or take a different approach?
I don't let them make that decision. I make that decision.
Ah.
because they don't know the factors. They don't know the judge. They don't know how. I mean, I will tell you, there's obviously cases where it's on the line and it could go one way or the other. But if I think there's enough, if there's things that are so obvious, like there's drugs, there's alcohol, there's abuse, those kinds of things are almost an automatic emergency order.
Mm. So then once this is filed, once this emergency order is filed, what should, your clients or other parents, what should they expect in terms of timing, other hearings?
Emergency orders are heard within 24 hours. So, I'm in California, so I'm speaking from California. But the California rules are: if you're filing an emergency order, you give notice at 10 a.m. the day before. You're in court the next morning.
Oh, wow. Wow, wow, wow. Well, that is a lot of information. We really appreciate all this knowledge. Do you have like a final message to parents that are listening right now, who are scared for their child and they're unsure what to do, or maybe they need to file this motion or think they need to file this motion?
What I can tell parents who hesitate is, you're worth it. So make a fuss, raise your voice, say, this is a problem. This is, I'll give you a hypothetical. My husband or my wife or whoever it is, or the grandparent who lives in the house is beating the child or hurting the child. Those you don't wait on. Those you go in. Um, or if somebody's got a drug or alcohol problem, you don't wait on those either. You have to kind of look at, it's like triaging. If you were a doctor, you'd triage and say, how desperate is this patient? Well, it's kind of the same way in family law. You triage what the circumstances are. How desperate are they? How bad are things? How much pain and suffering is a child going to receive if the court doesn't make orders immediately?
Well, thank you, Holly. Thank you so much for all of your knowledge. Per usual, I'm excited for the next episode as well.
Okay, thank you. I enjoyed it.
Thank you. And thank you for tuning in to the Lemkin Law Podcast, real talk on divorce and family law matters with Hollie Lemkin. If you're facing a situation where your child's safety is at risk, don't go it alone. Emergency orders can be powerful tools, but only when used strategically. To connect with Holly or learn more, visit Lemkin Law, that is LEMKIN law.com. And if this episode helped clarify the process for you, don't forget to like, subscribe, and leave a review. Thank you so much again, Holly.
Oh, you're welcome. I enjoyed it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.